So thanks everyone for being here. They told us that they were saving the best speakers for last because they wanted people to stay the entire conference. So we're that panel. I'm just kidding. Anyway, we've got a great panel to talk about ICO and STO, legal and regulatory overview. In the US, most of it's STOs. But instead of me trying to introduce everyone and doing disservice, we're just going to go down the line. They're going to introduce themselves, what they do, who they're with, and also give a little thought. Normally it's the last question of the day where someone says, what do you think about space, or what are you passionate about? We're going to reverse it and have them answer that as the first question because we're hoping that it'll kind of spur some ideation on your end. And if you have questions immediately after that, all of us are happy to immediately take questions. If not, we'll go into some questions that we kind of want to cover. So why don't we go down, Marcia?
Yeah, thank you, everyone. Thanks a lot for staying for this last panel. My name is Maria Prusakova, or Masha, and I'm a co-founder and counsel at Crypto Paralab and Advisory. We do PR for blockchain startups, but I also consult some startups on the legal side. I'm qualified in France. So I'm a French lawyer, and I hold an LLM from Berkeley. I used to work in M&A and finance law at Clifford Chance and Golding. And the question was what I'm passionate about in the...
Yeah, what you're passionate about, views, something you think people should be thinking about, from your perspective, yeah.
Yeah, so what's interesting right now in the industry is this movement from ICOs to STOs, and as you may guess, one of the reasons is basically regulations that people noticed that you better do a funding round which is legal and where there is a certain framework about what you are doing. So one of the companies we work with, ICO, they chose for the STO as well, and they're fully regulated in Europe. And I think that in the future, the future is for STOs and for the regulated fundraising.
Cool. Georgia.
Okay. Hi. Yes, thank you again to those of you who stayed. You are truly hardcore, and you will be rewarded. So my name is Georgia Quinn. I'm the general counsel at CoinList, securities attorney. And just to kind of echo what you were saying, I really do think we're entering a new phase in this industry and in this space, and it's something that I'm really excited about. I know a lot of people are mourning the death of the ICO, and frankly, I'm happy to see that go. We also are getting a little caught up, and hopefully we'll be able to discuss this later, in like the terminology, ICO, STO, blah, blah, blah. It doesn't matter. It's you're raising funds for your project. And however you want to do it, whatever you want to call it, you need to make sure that you're doing it in a legal manner. And I think people are realizing that. We're moving forward, and that's great. And now we can start thinking about like the really cool challenges with blockchain technology and the law, and start thinking about things like clearing, settlement, custody. How can we create exchanges to have liquid markets for these instruments? And so that's where I am excited to get to, and kind of leave this concept of security, not security. How do we issue it behind?
Marty? My name is Marty Tate. I am a securities lawyer as well. I work for a boutique firm out of Salt Lake City. I've been in this space for a few years. Some of us go way back. We were involved in the crowdfunding space, and it was maybe 2 years ago, 18 months ago, I was speaking at a convention like this and on a panel, and that was the first time people started asking about, well, what about crypto? And I'm kind of famous for saying, well, I don't think it'll go anywhere. And I think Bitcoin at one point was at 1,200, and I said, I think it's maxed out, and it went up to 20,000. So there was like actually a meme of that going around. So I'm excited about the industry. I think that it's amazing to see where it's just what's happened over the last year. And how 6 months ago or 8 months ago, just the excitement that was there. I was getting multiple calls a day from people saying, I want to do an ICO, I want to do an ICO. I spent a lot of time trying to challenge that thought and perhaps even talk them out of it, because like Georgia said, it's just fundraising. And so this idea of selling tokens as securities, I'm a securities lawyer, that always made sense to me. I'm glad to see sort of the industry evolve towards that. I'm excited to see as the regulators and the technology are able to sort of get on the same page. I think that the buildup will break, the dam will break, and I think we'll see really a revolution in the industry as you see this secondary markets and liquidity. So that's something I'm very excited for, and I think that putting things on a blockchain and tokenizing it is fantastic. So.
Thank you all for still being here, and thanks to Joseph and Alon. I think this has been a fantastic conference. I'm really excited to be here in California because, you know, all of us talk about the sandboxes, and the reality is when you come to California, it's one big beach, and everyone has all sorts of different types of exciting ideas and innovations. So what a little bit about my background, I'm a Paul Hastings. I know people hate lawyers. I'm one step beneath that. I'm a lobbyist. Some people call us swamp creatures. But I spent most of my time on Capitol Hill, on House Financial Services, on the Senate Banking Committee, and at the Treasury Department. And I've worked on almost every major piece of financial services legislation, but most notably when I was with Senator Toomey on Senate Banking, I worked on the Jobs Act, which made it easier for companies to either stay private or raise capital by going public. And that's what got me into the crypto space, because folks that either lobbied for the Jobs Act, grew out of the Jobs Act, or business models are based off of the Jobs Act, they're really in the space because it is about raising capital. And most, you know, quote unquote ICOs or STOs, they are using the exemptions that are from the Jobs Act to raise capital. So what I'm really excited for is, the future. And, you know, the future is the use cases that are going to come out of, I don't even like to say blockchain anymore because I've been around some technologists that they're saying we don't use block or chain anymore. It's really just DLT. So I'm excited about the folks that are remaking Wall Street and the back office. I'm excited about like new payment systems that can move money faster than Visa or MasterCard or SWIFT. But I've taken people around. I'm excited about I think we're going to see this renaissance of innovation, whether it's, I have a company that I'm working with that's partnered up with a drug company that is using DLT to be able to see when somebody takes their medication. They're using it for IP protection of every single part of a film. They're using it to monitor fish on a fish farm. So my excitement is what is coming, and what is coming is enormous. And I know there are those who are, they're disappointed sort of in the utility versus the security token. And I would say two things to that. One is that Jay Clayton, as well as Capitol Hill, who's working on Jobs Act 3.0, are very receptive to making it easier to raise capital within our securities laws. They don't want to reinvent the wheel and create a whole new asset class. And so there's already an effort and a friendly environment to get those types of changes made. It's just working off the same song sheet. And then lastly, what I want to say is there are a lot of people that will say, well, we're losing out to other countries. And that's just not the case. We're losing speculation, but we are not losing out on innovation.
All right, so my name is Jor Law. I'm just a kid in the space, interested in the space. What I'm excited about typically is trying to figure out the compromise between kind of the regulatory demands, legal and business practicalities, and the limitations of blockchain technology, and how to bridge that gap, and finding the compromise between kind of the people that want to do it the old way and kind of the crypto purists. Those two things are kind of very interesting to me because I don't think you can find a solution without a marriage of both. So you guys kind of have a little bit of background into what each of us does. Are there questions that anyone has right now? At all? None? Okay, cool. So we wanted to just clarify some terminology.
There might have been one person that was about to.
Oh, who?
Yeah.
Yeah, come on. There's mics.
Thank you so much. My name is Gennaro. I have a small company that does export-import business, and also I have a crypto trading, and I'm trying to do arbitrage with some companies. But basically, my question is that due to the new hybrid models, basically, I was thinking that, let's say, if in the US, in California, if you want to create a company, you have like to register at the Secretary of State the shares that will be issued. So basically, if you're doing like an hybrid model, the only thing that you may be doing is like for each share that you issue and register in the Secretary of State, you may also simply have another token that will be the digitalized version of that share, and that will be basically all to comply? Or maybe it's too simple?
Yeah, I can do that if someone wants.
I can do, or you can do, or.
I'll do it because I have a question for you on structures right after.
Oh, excellent.
So there's multiple ways you can do it, and that's actually a question that I was going to ask the panel about regarding kind of ICOs versus STOs and what a STO really is. And in my mind, there's kind of two types of STOs. There's the ICO that is actually being sold as a STO because they've admitted that it's some form of securities through a form of investment contracts, et cetera, and they're being compliant. And then there's another group of people out in the industry that are using STOs to mean like, oh, but it's real equity that we're selling, and we've just tokenized it, right? So what you just described is a company that is issuing its shares and its true equity as recognized under the state law, at least in the US, and those shares are either also represented by a token or actually are represented a token, and there's no paper certificate at all, right? So that's one method of it, but there's also structures where you could, for example, you could create a special purpose vehicle, and you can just have all the economic benefit comes through in the form of like an investment contract, and that's tied to a token, or like revenue, and that's tied to a token, so that what's being sold is not technically equity in that company. Does that kind of answer your question a little bit?
Yeah.
Okay, cool.
I'll add one thing to that, and then George, I'm sure, will as well. But I think one of the things that I get a little frustrated with is we talk about this utility token, security token. They're not mutually exclusive. As George said, you can have create a cryptocurrency or a token that has full utility within your ecosystem, but because of the manner in which it's sold, or the expectation of the purchaser, or the speculation, or the timing, or whatever, it would be deemed a security because of those reasons. Likewise, there might be something some sort of instrument that kind of functions as both, but you sell it as a security, but it also has, it might have revenue sharing, but it might also, in addition to that, have it does something within the network. So those terms really shouldn't be mutually exclusive. I think that it can be both. It can be a currency and a security and a utility and a lot of different things.
Yeah, and just to get back to like the specific question you had, I think you ended your question with, oh, if I just have an interest that has this, it's a token that is really representing a share, does that get me around it? And that answer is no. Okay. Because everything you just described, they're all securities, right? So the equity is a security, and then an instrument that is a representation of that equity is also a security. Okay. So you have to find an exemption or register either of those that you want to offer. And also, if you're truly interested in doing this, Delaware actually allows you to issue tokens as equity. So you can have, a DLT as your, stock ledger.
So, thank you. So, may I have another follow-up? Is there another question? It's because about the service token. Oh, sorry, the utility token. It's because under U.S. law, you got like FinCEN that is regulating all the rewards members, everything that it's like rewards points, rewards programs. So if you have like a utility token, it's basically that. It will be like a prepaid card or like a
Starbucks
reward
points.
program. Yeah, Starbucks points. And I assume
analogy.
that under FinCEN, you must comply as an MSB, or no?
Marty?
Sure. So one of the things that's so beautiful about this is there's so many possible regulations that you have to deal with. So
For a lawyer.
yeah,
But
for a
a
lawyer,
lawyer, right?
Well, and I guess it's beautiful. So in that situation, and Georgia just said, yeah, I love that Starbucks example, yeah, or the airline miles. A lot of it, so you can look at it and say, okay, great, what does it do? But also, going back to what we said before, how is it sold from the initial and what's the expectation? So even if it fully functions like, and I get that all the time, people say, well, this is just like rewards points. This is just like a Costco membership. This is just like so many other things, but the difference there is what's the expectation. One of the things that the SEC would focus on is what's that expectation of both the issuer, are they selling it to try to raise capital to fund the build out of the platform, but equally as important is what's the expectation of the purchaser. Are they buying it because they really just want to use it as a Starbucks card and go and redeem those points? Or are they thinking that it's going to be put on an exchange and it's going to go up in value? Arguably, if it's really just and somebody can correct me if they disagree or think otherwise, but if it really is just a membership point and it really only functions in that ecosystem and it's like a currency, then yeah, maybe it's not security, but then you get into the whole,
What is it?
Yeah, what is it? And if it's a currency, then do you have to have or do you have to need to be an MSB and have a money transmitter license? And the answer is, in some states, possibly yes. So.
Yeah, I mean, don't lose hope.
Yeah.
I am a firm believer that there is a utility token out there, that it is totally possible.
I agree.
The problem is we just haven't seen many of them yet, right? We, at CoinList, we work with a lot of companies that are working on developing them. They've done some initial fundraising. Those initial fundraisings were all deemed the offerings of securities, and we treated them as such. But that doesn't mean that eventually, once they have their networks up and running and they have a fully functioning ecosystem with a token that is utilized within that network, those would still be securities. In fact, I'm betting they won't be. I mean, I literally am like betting with my career that they won't be. So, so again, it's always going to be like a facts and circumstances analysis, and but it is out there. It is.
Yeah.
I was going to say, I have a client where we had we bifurcate, so he has a virtual wall along the Texas border and was planning to expand it, just cameras, no walls, cameras, expand it across the whole border. And the cameras are already up along the Texas border, and so that piece of it is really a utility token because you're going to be able to tokenize it and have use of it right away. But to the extent that he was going to raise funds to build the rest of the virtual wall, we treated that as a private placement. So I mean, we bifurcate a lot of these cases.
Yeah, let me add something. So if you look at what SEC is saying, basically what they say is that every single ICO that they've seen to date, it's been a security token offering, and it's not an utility. So what a lot of companies do is that they still register or go under the exemption and claim it to be a security just to be safe on the SEC side, because so many ICOs right now, the SEC is going after them. So just to be safe, you go under the exemption, and then throughout your journey, you can do an utility token afterwards. So you start as a security, you do an exemption, and then you continue as an utility. So this is what many companies were doing because basically SEC is so strict, so you just don't want to get in trouble.
Yeah, you kind of have to be careful. Obviously this will seem self-serving, but I don't practice anymore, so not that self-serving. Obviously, check with an attorney. Once you go down the path of treating your tokens as securities and you're doing them through some sort of exemption, you've actually got to comply with that exemption. And if that doesn't work with kind of your token economy, you you really have to analyze the effects of that. But we have CoinList does some of like the biggest and most prominent deals that the industry has seen. And Georgia, can you maybe talk about some of the common structures that you guys have allowed onto your platform or liked or not
Yeah,
liked?
sure.
Thank
I
you.
mean, as I just mentioned, every offering that's done on the CoinList platform is deemed a security. And so we find an exemption under the securities laws to be able to conduct that offering. The most frequently used exemption is 506C, which allows for general solicitation, but you have to take reasonable steps to ensure that every investor is an accredited investor. And so that's the typical structure that we use. A lot of the tokens or the projects are anticipating that in the future, when they actually issue the tokens, so they're issued on a SAFT for the most part, which people say what you will about the SAFT. You can love it, hate it, doesn't really matter because they're there. And the issue with the SAFT is that it's initially treated as a security. It's like a forward contract, basically, for the tokens. And then the hope is that once those tokens are actually delivered in payment, in extinction of that SAFT, those tokens will then be deemed utilities, and then they can be traded and utilized on the network without all of the holding restrictions and other restrictions that come with having securities. And so, for the most part, all of the offerings that have been conducted on CoinList are still in the holding period, because once you do a private placement, there's generally a 1-year holding period where you can't trade those securities anyway. Moreover, those projects haven't actually dropped their tokens yet, so this is kind of a non-issue. But that is really the structure that we we don't advise, we don't provide legal advice, but that's really what we're seeing, and that's basically what market is. Another thing that we're really excited about is airdrops. And so for those of you who don't know what airdrops are, it's companies that are basically issuing their tokens for free in order to generate inertia around their project, gain users, reward early adopters, and just, it's for lack of any better term, it's a marketing ploy, but it's been very successful in a lot of cases. And so what people don't realize is that even if you're giving away these tokens for free, it's still deemed the offer or sale of securities by the SEC. So even though you're not actually making any money, you still have to register or find an exemption for them. And so we've been working with issuers to find applicable exemptions to help them, and also to really streamline the process so that it actually feels like an airdrop and not like I'm investing in a company and going through this diligence process and doing all of this. So I hope that answers your question, but I'm available for follow-up.
It does. Two follow-ups.
I have a question. Can I ask a question?
Yeah, sure.
Hi, I'm over here.
I see lights and
Sure.
voice.
Everybody started talking in kind of abstract and security token and utility token. Let's take a real live example. I'm a lawyer, and we're just talking this internally in our law firm. So what is a casino chip? And that's a token, basically, has real value. It doesn't trade, but it's portable. You could take one chip from one casino, and you could use it, and they'll cash it out in another casino. So what is that?
I'm not in this space, but
This is like gambling.
it's just a representation, though. It's almost like I would argue the difference on that is that the value doesn't go up, right? You can't speculate on a casino token. It just the value is what it is.
So is the crypto community basically saying that the only token that should be promulgated or promoted is one that's going to increase in speculation value versus using a token that has a exact value that you could basically measure, whether it's in terms of a private equity situation or a private placement situation in lieu of hard currency itself? Because you can see that in terms of gold bullion and silver situation. So why is the community limited itself in terms of speculative part, which is basically draw attention to the bad guys or the not so good people who are trying to feed on people's greed, when instead of using utility token like a computer, like a casino chip or bullion, to basically facilitate transaction and limit the amount of hard currency. For example, if you give that kind of token, casino token, to the migrants who are traveling across the border in different boundary line, they wouldn't have to go through the currency exchange. They could basically cash it at full value at whatever place they're going to. And that's what IBM's working on.
Right. So I think, I think I would frame the question differently. I don't think anyone on this panel is a gambling expert. But that being said, I don't think it's a matter of, anyone saying the crypto community is doing this versus that, right? Who knows why baseball cards are not, securities and why they are, and who knows why a gambling chip is not, other than they put a whole body of laws to govern that it is now gambling. Like, trust me, you probably wouldn't want your tokens to be under gambling laws, right? So you pick your poison. Is it going to be a true utility, unregulated? Who knows? Is it going to be regulated by FinCEN? Is it going to be regulated by CFTC as commodities? Everything else, everything you mentioned as an alternative there was in some sort of regulation, right? Now, which regulation is it going to be in? I'm not quite sure. That everyone's figured that out yet. If that's one of the problems. If the real issue with security tokens is that it's pretty clear when you go to most companies that are doing some sort of ICO or token offering that they intended it to be some sort of capital raise from investors, right?
Understood.
Right? But that alone pretty much makes it securities in most cases.
Understood. I'm basically saying, but you're limited the token itself to one of a security token or utility token. You're not using the application of token for everyday use, which is the big utility the everyday person could utilize and cross all kind of borders. And the best example is the casino chip. You could take it all over Vegas, you could take it over anywhere else, and people will even take you to the grocery store and people will cash you out.
Yeah,
So
I challenge your assumption because we're working with a lot of companies who are using blockchain technology to build things exactly like what you're talking about. So so the like George said, like the crypto community, whoever that is, we're not going down one single path and saying it has to be a speculative thing. Everybody's working on their own projects, and we're going to get all,
And that's what I'm saying. Basically, I'm saying the community, the conversation should be not one focus in terms of capital raising. It should be across the board in terms of all kind of utility. Because otherwise, the crypto community is going to come across like a bunch of slime artists basically trying to take people's money.
Yep, agreed.
Well, so basically, the problem with utility tokens and why so many ICOs got in trouble, because you say that it's an utility, and that's not an example of the casino chip. But those tokens claim to be utilities, they grow in value, because what is a security according to Howard test? That's an investment contract which is gaining value thanks to the managerial efforts of third parties. And what is utility doing? The company, when they're issuing tokens, utility tokens, they're still interested in those utility tokens to go to exchange and raise in value. That's how their investors will gain money. So a lot of utility tokens, they are raising in value, and that's why they're being qualified as securities.
Well, that's being sort of not mutually exclusive.
Can we take this conversation offline? Because I think we're spending too much time on this one topic.
Because I was going to say this.
I think we agree with him.
Yeah, I was going to say one thing really quickly was a lot of these, in terms of utility tokens, they are very facts and circumstances cases, and so you have to hear sort of the whole scenario before you determine how it's going to be regulated. And I would say that the biggest change that we're seeing is really the technology, and that the laws haven't kept up with the new technology.
Yeah, and I don't think anyone disagrees. Like, none of us want everything to always be securities, but we're lawyers, we practice the law as they're interpreted by the folks that we have to kind of deal with. And if they think every investment of every ICO is a security, then we kind of have to play that game a little bit, even if we don't necessarily believe it. But one thing I want to touch base on, because many panels in the U.S. don't have the fortune of having foreign attorneys on them, is I want to talk about jurisdiction issues in jurisdiction shopping. A lot of people just think, oh, well, I'll just go to this other country and that's better. And for various reasons, that may or may not be great, but Masha is here, has experience practicing in foreign jurisdictions. He's here in the US. He understands how it works here. So maybe you can give us some insights on that.
Yeah, sure. So when you decide to launch your STO or ICO, or when you think where to incorporate or your company, your exchange, or your fund, so what you do, you will analyze different jurisdictions, and at the end, especially in Europe, you will come up to the three of them: the blockchain island, which is Malta, the crypto harbor, which is Gibraltar, and what's the third one? Yes, exactly,
Zug.
Crypto Valley, Zug. So talking about those three jurisdictions, I can say that what would you be looking at? These are the few parameters, which will be if it's blockchain friendly, if there is a certain stability, if there is a security, what is the cost to run operations, what is the taxations, and what are the banking rules, and what are the regulations. So if we look into those three countries, so Gibraltar, Malta, and Switzerland, I could say that the trend is that Gibraltar is winning together with Malta, and Switzerland is losing a bit of its trend, although in Switzerland we know that Ethereum Foundation chose Switzerland as their place of incorporation back in 2014, and that's how Switzerland became the crypto nation and crypto valley for Zug. If you look in the tax, from the tax perspective, in Gibraltar we have 10% corporate tax, while in Switzerland, in Zug, it's 14.6%. If you look into the stability of the country, and you look into Malta with all the corruption, all the crimes going on there, all the Italian mafia, you can be a bit of afraid. When you look into Switzerland, it's very strict. There is no corruption. You are certain that things work well. If you look into the laws and regulations, we know that in Gibraltar we have the DLT regulation, which is enforced since January 2018. In Switzerland, we have the guidelines of FINMA. There is no exact law which addresses the ICOs, but only the guidelines. Talking about Malta, we know that on the 4th of July, there were 3 major laws which were proposed, and we still wait for them to be certainly adopted. So Malta is pretty ahead. And I think that when you choose a jurisdiction, you need to look in all these parameters and also look into companies which do something that you do, and where did they choose to go? Like, where did Binance choose to go? Where did OKX chose to go? And if you're an exchange, you may consult with them, with your lawyer, and see where's the best for you. Also, for instance, I can talk about Mauritius government, who approached our advisory firm on Bali during the IMF and World Bank Summit. So the Mauritius finance minister came to us and said, we want to become a blockchain nation too. Can you help us? We have all the laws, all the banking laws which are favorable. We're a tax haven. How can we become next Malta? How can we become next Gibraltar? So lots of those small countries with a small population, Gibraltar is only 33,000 people living there. So all these 3 small countries, they're much easier to adopt the favorable blockchain regulations because they already are as banking or tax havens. So that's from Europe.
Yeah, I'd just like to follow up on that, that is a great analysis of those 4 countries as far as if you are a blockchain company and you just want to have basic operations, but to the extent you want to issue tokens to foreign citizens, specifically US citizens, or you want to raise money from US citizens, none of that matters. You still have to follow US securities laws, and so unless you want to just take investment dollars from those 4 countries, the population of which I don't think even equals like Virginia, you're going to need to look at the laws outside of those countries. And a lot of different projects have gone and they've incorporated in those places and found out that they still have to go through the entire US regulatory system in order to raise money. And also, like, from a tax perspective, most US corporations don't even pay taxes. So 14%, 20%, whatever, it's probably going to be 0.
I was going to say you have to comply with Reg S. The SEC considers itself to have global reach, and you have to ironclad yourself or have smart contracts to make sure that you're not going to have a stray token be bought by a U.S. investor. So there's definitely a lot of, we do a lot of legal work around when there are companies that are trying to avoid the U.S.
Likewise, one of the things, sorry, and also I'll take it one step further. We get a lot of clients that come and say, okay, well, great, we know we can't sell it within the U.S., but what if we set up a Cayman entity or we set up in one of these other, friendly jurisdictions? What if we sell there and we'll just geofence the United States, which theoretically it could work, but you're going to have to get that money back here. And if you're based here in the United States and you're using United States, telephones and mailing system and internet and everything, you're creating a nexus here. And if you want to do that, I guess you could, like you said, you could move to those other states. But then there's no perfect solution.
Right, and also like the EU has securities laws.
Yep.
UK has securities laws. So just because you're in Malta doesn't mean you don't have to comply with, it's the locus of the investor and the token holder, not the locus of the company that you have to look to.
So I'm going to ask a question that I think, always gets asked, when we say these things. Dina, you touched upon it. So some brilliant person in the audience will say, well, what if I'm not a US company, I don't sell to the US, and then it gets exchanged there and it's outside my control? Then what?
Oh, you mean it's...
If it gets in the hands of it's the Reg S issue. If it gets
Yeah,
in the hands of the
you
US
hit the
person.
Reg S issue. Yeah. I think it's important to talk a little bit about the SEC, because we made a comment before about sort of the SEC and being harsh. And I mean, I am a libertarian, free market, moderate Republican type of person. So what I would say is that the SEC is actually trying to be incredibly careful. Jay Clayton, the last thing in the world that he wants is to be hauled up to the hill, and we find out that a bunch of retail investors have lost a lot of money. So they're going after sort of the true fraud and the low-hanging fruit. But the reality is, if you are developing something that's like truly unique, they are open door. Like they just developed this thing called FinHub at the SEC, and this is true. All the agencies are kind of establishing these type of things. So, I mean, I have taken many people in to meet with the key players at the SEC, even the commissioners. They feel like they don't have their minds around it, and so some people say, well, the U.S., they're behind, they haven't done anything. Well, part of it is they're trying to sort of step back first and get their arms around the industry, because they don't want to quash innovation. So I would say they're trying to put the welcome mat out there. It might not seem that way, but that's my experience from taking people into the SEC.
Okay, one last question, I think.
Good afternoon, my name is Fabio. I'm a Swiss-based lawyer. We have an office as well in London, another one in Valletta in Malta, and a partnership in Gibraltar. We've been in the field for about almost 3 years. We did a couple of ICOs there, about 9 so far. And it's interesting what Masha said, that it's important to analyze which jurisdiction is going to choose. There is a couple of interesting strategies we have been putting in place to raise money from American investors in ICOs done abroad. And we'd like to talk with you as well about it. But there's also a lot of ideas about the general image in the world, as you probably know, is that everybody wants to avoid the SEC, not because they are very strict or they want to save frauds, because frauds have been along with money since they created money. So it's a bit of paranoia the SEC have. And the thing about the SEC, as we saw, and excuse me to say that, but is that they don't have a deep understanding of what it's saying. Like 1 week they say something, 1 week after they say something different. And that's a good point about Europe in general, not all the countries. But the things that doesn't happen like from night to day over there. Like the community got organized in Crypto Valley or in Malta as well, or in London as well, to try to pass legislation that was slightly more understandable of the situation. And that's why I'd like to know, to ask you guys, if there is some form of organization, a community here, to approach the SEC with some, to raise awareness on them about what's the real nature of the tokens, or how does it work differently, and so on. And also, if there's something going on in terms of criticizing the Howey test as a valid proof of a security token. As I think it was Masha that said that everything can be qualified as a security token if the value of the coin increases. what's reasonably absurd, because all the coins are made to increase their value, even asset-backed or payment and so on. So yeah, I'd like to know if there's something that you criticize on that, because most of the countries, like other serious countries, don't use Huawei test anymore.
Yep. So we normally would answer that question, except for there's a flashing screen that says wrap up. So we'll talk on the side,
Okay, perfect.
perhaps? Okay, great. Thank you, everyone,
Thanks,
for joining
everyone.
us.
Thank you.
Thank you.
Thank you.